15th lecture note. The title of this lecture note is Civil Law. We are going to look at this in four aspects. The first aspect, subjects and objects of civil law. The second, the right of ownership. The third, obligation, transaction, contract. The fourth, types of civil contracts. Let us look at the first aspect, subjects and objects of civil law. Civil law is a branch of Russian law that represents a system of legal norms regulating property and related personal non-property relations. Property relations include property and obligation relations, and personal non-property relations are those that arise in relation to non-material goods, that is, life, health, honor, dignity, and so on. The main source of civil law is the Civil Code of the Russian Federation. Signs of civil law are equality of rights of subjects, their freedom of will and property independence, polyploidy. Subjects of civil law are 1. Individuals, that is, people from birth to death, has the civil legal capacity, that is, the ability to have civil rights and bear obligations in mental sanity, and upon reaching a certain age, a person acquires civil capacity that is totally incapacitated persons under 6 years to 14, and from 14 to 18 years of age increase a diminished capacity. With 18 years is fully competent. That is the ability of their actions to acquire rights and obligation. 2. Legal entity, that is an organization that has separate property and is responsible for its obligation, may acquire and exercise civil rights and bear civil obligation on its own behalf, and may be a plaintiff and a defendant in court. Types of legal entities. The first type, commercial, that is organization that pursue profit making as the main goal of their activities. Businesses, partnerships, and companies, for example, GSL LLC. The second type of legal entity, non-commercial, that is those that do not have profit making as a goal and do not attribute the profit received among participants. For example, foundations, institutions, public and religious organizations, and legal entities. Objects of legal law objects of civil law include things that including cash and documentary security, other properties, including property rights, that is non-cash funds, non-documentary security, digital rights, results of works and services, protected results of intellectual activity, and means of individualization, that is intellectual property, intangible goods, for example, honor and dignity. Let us look at the second aspect, the right of ownership. Ownership, the right to own, use, and dispose of property. The right of ownership means the possibility of physical possession of a thing, economic influence on it. In addition to owners, the legal owners of things can be persons who own real estate under a contract. For example, by virtue of a lease agreement, persons who have received a certificate of inheritance but have not registered the transfer of ownership, and so on. The right to use is the right to extract useful properties of a thing by using it. In the course of use, the property is either completely consumed or worn out, that is depreciated. The right to use is closely related to the right of ownership, since, as a general rule, you can only use property by owning it. The right of disposal. The right of disposal is understood as the right to determine the legal fate of a thing, that is sale, gift, and lease. Unlike possession and use, the right of disposal is exercised only by the owner or other persons, but only at is direct discretion or direction. Some types of property may not belong to separate categories of owners, that is restricted in free civil circulation or withdrawn from such property. The right of ownership is one of those subjective rights that can arise only if there is a certain legal fact, and sometimes even a combination of them. These legal facts are called the grounds of the emergence of property rights. The grounds for the emergence of property rights are usually divided into initial and derivative. The initial grounds for the acquisition of property rights include cases when the right of ownership of property arises, that is acquired, independently for the first time or independently for the rights to the things of their previous owner. In the original method, the right of ownership arises for objects that have not yet been the property of someone else, or for objects that, although they were the property of another person, but are placed at the full disposal of the new acquirer, regardless of the rights of the previous owner. Derivative grounds grounds for the acquisition of property rights include cases where the acquirer has a property right based on the right of the previous owner. The right of the acquirer of the property depends on the rights of the previous owner. The right of ownership is terminated when the owner alienates his property to other persons. The owner renounces the right of ownership. The property is destroyed and the right of ownership of the property is lost in other cases provided for by the law. For example, compulsory seizure when foreclosing on obligation, requisition, confiscation, appeal to the state revenue. Let us now look at the third aspect: obligation, transaction, and contract. The concept of obligation, transaction, and contracts are basic for the law of obligation. An obligation is a civil legal relationship by virtue of which one person, the debtor, is obliged to perform a certain action in favor of another person, the creditor, transfer a thing, perform work, or refrain from a certain action, and the creditor has the right to demand that the debtor perform its own duties. Obligation arise from contracts and other transactions as well as a result of causing harm, unjust enrichment, or other grounds specified in the Civil Code of the Russian Federation. Transactions, that is, actions of citizens and legal entities aimed at establishing, changing, and terminating civil rights and obligations, can be either unilateral, like a will, or two-sided or multilateral. A contract, more narrowly defined, is an agreement between two or more persons on the establishment, modification, or termination of civil rights and obligations. In other words, a transaction that requires the expression of the agreed will of two parties, that is a bilateral transaction, or three and more parties, a multilateral transaction. Thus, the concept of a contract is included in the content of the broader concept of a transaction, while the concept of an obligation is only partially related to them. Let us look at the fourth aspect: types of civil contracts. You can build a system of civil contract based on the legal results that they are aimed at achieving. This system is taken into account in the agreement of contract regulation in the Civil Code of the Russian Federation. The first, contracts aim at the transfer of property. Agreements to transfer property, including onerous contracts for sale, barter, rent, and free gift contract, and contracts aimed at the transfer of property in use, including onerous leases and tenancy and gracious loan agreement. 2. Contracts for the performance of work. These groups include contracts for the performance of research, development, and technological work. 3. Contracts for the provision of services. Among them, they are directly paid services contracts and contracts for the provision of certain types of services, that is, transportation, freight forwarding, loan and credit, financing for the assignment of a monetary claim, bank deposit, bank account, storage, insurance, instruction, commission, agency, trust management. 4. Contracts aim at transfer of intellectual property rights, which unlike other contracts, are regulated primarily by Part 4 of the Civil Code of the Russian Federation. These are agreements on the alienation of an exclusive right and agreement on the transfer of the right to use the results of intellectual activity. For example, a license agreement and a commercial concession agreement. 5. A special group consists of agreements aimed at creating association. For example, a simple partnership agreement, joint activity agreement, a constituent agreement of a business partnership. In addition, contracts can be divided into paid and gracious. A paid contract is a contract under the terms of which a party must receive a payment or other counterpayment for the performance of obligation arising from the contract. A gracious contract is a contract under which one party undertakes to provide something to the other party without receiving payment or other counter provision from it. A contract is considered to be paid if its gracious nature does not follow from the requirements of law, other legal acts, the content of substance of the contract. From the point of view of the substance of the contract, it is possible to distinguish contracts that can be 1. Only paid, that is, contracts for sale, delivery, lease, transportation, agency agreement, and so on. 2. Only gracious, that is, contracts of donation, gracious use of property, and so on. 3. Both paid and gracious, that is, storage agreement, loans, orders, and so on. The value of the remuneration of the contract is decisive for the implementation of business activities. Since entrepreneurs must act solely for the purpose of making profit, gracious transactions made by entrepreneurs according to. And with that, we come to the end of the 15th lecture. Thanks.